modern methods of interpretation. And as you see in the subtitle, we will try to see how you can combine the old or classic method with the new or modern methods. Modern methods have been growing out of a criticism of the classic methods. Fault or defects have been identified in the classic method. Understand here the exegetical method. There is a point of agreement in people who are criticizing the classic method. The very notion of the intention of the legislator, meaning legislator, not at the individual legislator, but the whole legislature or parliament, the legislative body that makes the law. That's a general meaning of the term legislator that you can use in the context of legislation. Well, discovering or trying to guess what the intent of the legislator is uncertain. We've discussed that. When you look at parliamentary proceedings, there's stuff that is political, there is stuff that is legal, it is collective decision, how can you find, it's already difficult to find the intent or intention of one individual, how can have a collective body have intent? So a lot of skepticism has been shed on this very concept of legislative intent. And also, and that's probably the more severe criticism, these scholars say that it may be inappropriate when you have a very old text and a new legal problem to second guess the legislative intent, because how could they have imagined when they wrote the Civil Code in 1804 that we would have computers, that we would fly airplanes? They had no idea about the technology that is part of our daily life nowadays. So that's the point of agreement, if you will, among the scholars. They say, well, when you have these very old texts, especially, it's quite artificial to second guess the legislative intent. There is, however, a point of disagreement in this criticism. Is that there is no consensus as to what substitute you should adopt to the exegetical school of thought. So let us see what these modern methods are. And I'm here working from a classic in civil law literature, the Précis by Jean Carbonnier, was a very, very famous French scholar and is explaining, the modern methods. And you have read actually the excerpt in my course supplement. He first identifies the method of the social end, a sort of sociological approach saying that to make sense of the law, you have to understand the sociological context under which it was adopted and what is the social purpose of legislation. Another modern method is the evolutive method that is a cousin to the historical school that we have identified in Germany. And the whole idea is that societies are in flux and the law should evolve with society. And you have to accept that what was regarded as being the proper interpretation of the law in a given context may change with evolution later on, further down the road, okay? The third modern method identified by Carbonnier is the structuralist method, which has a focus on the structure of the text, the way the code is organized, all the categories that have been inherited from Roman law. And based on these structures, you try to work your way through interpretation. And you have also the free scientific research that will be discussed with much detail in this video. It is a method that combines 1 and 2, the sociological approach, the historical approach, and And number 5, yes, it will be discussed also below. But Carbonnier, however, does not discuss it, but other scholars point to the existence and the predominance in a number of contexts of a teleological method or purposive approach. Rather than putting the focus on legislative intent, tried to find what the purpose of legislation is, okay? And that purpose may be adapted, to situations that may not have been anticipated by the legislators then. We will see that modern methods, it's not always clear. It's sometimes a mixed bag of all these approaches. And I'm going in this video to discuss the free scientific research, which probably is the prototype of the modern methods. But what is now free scientific research? You see here a portrait of a man that appeared on my slides about gaps and lacunae in the law, François Geny, who wrote methods of interpretation and sources of private positive law at the turn of the 19th and 20th century. And Geny said that when a new problem appears, a problem that has not been anticipated by the legislator, you should not second guess their intent. It would be a mistake to try to second guess, because these people could not have figured out the problem that you are facing now. So Geny clearly says, well, exegesis should stop at that point. Forget about the classic method, forget about exegesis. We got to work in a different way. One may opt for what he called free scientific research. I will elucidate the term a little bit later. But what Geny says is that this is a situation where, in his opinion, the judge should create the law, because legislation is not responding. It's a new problem that has not been identified. So the judge should move from the principles of positive law. So you find here a sense of purpose, okay, what positive law tries to achieve, whenever it exists. You should consider jurisprudence and doctrine, so the secondary sources, by the way, much like you do when you do exegesis, okay, that is ubiquitous in the civil law tradition. You always look at jurisprudence and doctrine. And also, and that's the new point that Geny is bringing to the conversation, pay attention to sociology and to economics, okay? The relevance, the significance of the social and economic context, okay, of decision making. By the way, Carbonnier, whom I mentioned earlier, has been also a scholar who's been writing about sociology of law, okay? So you see these social ideas, moving into doctrine from the late 1800 and the early 1900. So to put it in a short form, the judge is invited by Geny to act as a legislator, which are words that we have found in the Swiss Civil Code, Article 1. Remember that the Swiss Civil Code was adopted a few years after the publication by the book in Geny. So the judge must act as a legislator and devise a reasonable solution to the case based on what seems opportune, okay, what is socially and economically acceptable, and also based on equity, okay? The solution should be fair also in the circumstances of the case. Geny insisted that in doing so, there should be no arbitrariness, okay? Don't forget that the French have been very wary about arbitrary decisions of their judges in the past, in the time that preceded the French Revolution. He's not advocating for unfettered, unlimited judicial discretion. All this should be done reasonably, objectively, and the judge should use social data, okay? Using social data, you may say, judges, are they equipped to do this? Well, Geny says they benefit from the work of scholars, okay? You always have a body of doctrine, and not only the work of the jurist, but also the work of the sociologist, the work of the economist, okay? Look at the ideas of the time. So try to identify the needs of the time when you are making the decision. Try to identify the social ideas that exist at the time when you are to give the solution. Stop being obsessed by what legislators may have intended in time past, okay? Focus on the present time and what is at that moment, okay? Identify the social needs, identify the moral needs of the population. Try to identify a sense of purpose that matches the present needs. And do not neglect a sociological approach, and be animated by a strong sense of justice and equity. I'm giving you a rough summary of hundreds of pages of the book of Geny, but you have in the course supplement a beautiful summary by Professor Boris Stark, who was professor at the University of Lyon. Now, the words free scientific research sounds a little bit odd, and this is language that has a sort of late 19th century overtone. Let me translate the idea into modern language. Okay, the original words in French are libre recherche scientifique. These are the words of François Geny. And the literal translation that I have used thus far is free scientific research. Free, there is no problem with that term. We understand that the judge should be free from existing text, okay? I'm free, I've got to adopt and create the law. Scientific is a strange word because we see scientific, that sounds abstract. You think about scientific abstract theory. And Geny actually meant it in a very practical sense. Geny was a pragmatist. And he's using the word research that sounds like a purely academic activity, but actually Geny meant a search. He made the dynamic process of searching a rule. Actually, the book of Geny has been translated into English. And guess what? The translation has been done here in Baton Rouge. It has been promoted by the Louisiana State Law Institute and the Center of Civil Law Studies. And the translator, Gerald Maida, was actually a Czech who was very familiar with French and English and thought, literal translation, by the way, would not be very much the idea of Geny. You know, Geny says you've got to be a bit creative. So he tried to be creative and use contemporary language to describe the method of Geny. The word free has no problem, so he starts with free. But instead of scientific research, he has free objective search. You are searching using objective criteria, but he thought that the phrase also has to tell the reader what is it that you are searching for, because free scientific research could apply to astronomy, to biology, to physics, to anything. So he has coined that phrase, free objective search for a rule. Objective translates scientifique. You know, it implies the use of objective data. Search is the dynamic process to identify a rule and not a purely academic research. Rule is what one is ultimately looking for. though it is implied in Geny's phrase. Sometimes when you translate, you have to express, hey, well, the silence or the gap that you have in the original term. So feel free either to use free scientific research when you discuss that, or free objective search for a rule, which is more explicit. If you want to know more about François Geny, there is an abundant literature in English. Judge Albert Tate, one of our great Louisiana civilian judges, wrote a review of the translation that was published in the Louisiana Law Review. Nicolas Cassirer, who is now on the Supreme Court of Canada, has a beautiful article also in the Louisiana Law Review about François Geny's Libre Recherche Scientifique as a guide for legal translation. A French scholar who has visited Louisiana several times, François-Xavier Carry, has studied the impact of the thinking of François Geny in Louisiana. This time it's published in the Journal of Civil Law Studies, published also at LSU. And for those of you who read French, you can read my article on la traduction de l'œuvre de François Geny, méthode de traduction et sources doctrinales. Now, what was the reaction or the response to the thinking of François Geny? Let me start with the common law world. Interestingly, the ideas of Geny were welcome in a very friendly and enthusiastic manner by a number of American scholars, and particularly the legal realists. Roscoe Pound, Julius Stode, Cardozo, Wellin have abundantly cited the thinking of Geny and saying, look, they were criticizing the formalistic approach and say, look, the French got it. And say that you have to rely on economic and sociological sources in a judicial making. It's actually, law in action. In France, it's not been that easy, okay? There's been a sort of tense reaction, and the invitation by Geny, who said, you have to go beyond the code, okay? The code is not addressing the problem. Go beyond the code, leave the code on the side and act as a lawmaker. Well, that raised big concerns in a country that likes positivism, who considers that legislation is the best or the ideal expression of the law. The tradition in France is to move by the code. You are moving and engineering solutions from the civil code. And what is this man who says we have to go beyond the code? The French felt uncomfortable. And one of them, a very talented scholar, Raymond Saleh, who had been actually influential on the thoughts of Geny, tried to bridge the gap between the conservative and the more progressive-minded scholars. He has coined that phrase that you have here in French, au-delà du code civil, mais par le code civil. Say, yeah, you have to go beyond the code, but by the code. Okay, you may go beyond, but don't forget the code. What does that mean? Okay, we got to clarify the thinking of Saleh. Saleh actually used these words in the foreword to the book by Geny. He had the privilege of writing the foreword. So the French have developed a praxis from the thinking of Saleh, okay? So when you are doing free scientific research, the judge is invited to identify some general provision in support of the new rule. Always try to find something in the code that may serve as a support to your creative doctrine that you try to push through based on the objective analysis inspired by Geny, okay? If you don't find such an article, you have nonetheless an alternative. You may find a general principle of the law, like the idea of abuse of a right, that has been convenient, okay, to fill one of the gaps in the civil code. the provision that you will identify will actually serve as an alibi, okay? It will sort of cover up your activism, because let's not hide, behind the words. Though judges cite to a provision, they are pretty much activists, okay? They're trying to move the law away from the original intent. But you have an alibi, you can say, oh, no, no, no. The idea is at the least implied in the provision that I'm citing in my judgment. So you have numerous cases in French law where actually you have bold deviations from the legislative intent. Judges are really pushing new doctrines because legislators are not doing their job and don't keep the legislation apace of evolution. So judges are trying to help and do their best. And actually, these deviations are not that obvious. Only trained lawyers can identify them. Why? Because the Court of Cassation, as we discussed earlier, does not give much detail in its judgment, okay? It's not giving articulate reasons in the judgment. They just say, given, whereas this article says that, and they say this article actually, implies this, and they do not reflect or express all their thinking based on scientific or sociological data, okay? Only the doctrine can figure it out. But when you read the judgment, it's as if the bold solution flows naturally from the language of the code. So it looks as if it were there in the code in the first place when it was written. That's artful, right? And in my article, Codes as Straitjackets, Safeguards and Alibi, that you have read, I'm giving in the last part of the article examples of such uses. I'm just giving you or reminding you of these examples where judges go beyond the code, but by the code. The article is discussing shifts in the meaning of old code provisions, engineering the reading of the civil code, moving away from fault, though there is obvious evidence that legislative intent was that all the law of liability, all French tort law was to be based on fault or negligence, but they use the general language of an article of the code to inject strict liability in substantial areas of tort law. Another example that had been floated a few years ago, less successfully though, is, when the idea of same-gender marriage came, took the stage, some say, but look, the French Civil Code never mentions that you must be of opposite sex or gender in order to marry, okay? There is no such requirement, the code is silent, and therefore there is no such requirement, and the code does not prevent you from marrying men with men or women with women. The argument has been made in courts in Belgium and in France, but it has been rejected by the Court of Cassation, both in Belgium and in France. Actually, the Court of Cassation thought, ooh, this is a big social problem. We don't want to resolve it from the bench. No activism there. We want a legislative debate. It has to be decided in a more democratic way by the representatives of the people. And here you have, with this modern method, a sort of conflict, Should you do this from the courts using the Geny method, or should you wait for the legislators to do the job? Well, there are times when legislation does not evolve quickly enough and judges find it safe enough to be bold and go beyond the code, though by the code, and other cases where judges are using self-restraint, which they, rightly so in my opinion, did with same-sex marriage. It was healthier for society to have a public debate on such an important matter. When filling the gap, modern methods, of course, are coming through. You know, gap filling is really the area where the thinking of Geny finds, you know, all its space, okay? It has been done regarding the protection of privacy or private life, and the text that was used as a support to do it by the code was the general tort provision saying, okay, it will be regarded as fault if you interfere with people's private life, and you will be liable, you'll have to face the consequences and repair the wrong. And ultimately, in 1970, legislation proclaimed in Article 9 of the code that everyone has a right to protection of one's privacy or private life. In the case of the abuse of a right, there's been no legislation in France that has been engineered by the court, as we saw in the gap filling class. They have used originally, again, the general tort provision that is the equivalent to 2315 in the Louisiana Civil Code. And finally, the Court of Cassation nowadays acknowledges that it stems from a general principle of the law. So, okay, we have now to wrap up and see a little bit how this new method articulates with the older method. One method does not replace the others. Exegesis is not to be abandoned. And as I said in the exegesis videos, most cases where codes and legislations are to be interpreted are done based on the classic method of interpretation. I ventured 95%, it may be even more than that. But the modern methods only apply to a tiny minority of cases, okay? The situations where you have a new problem or you have a social change that could not have been taken into account by the legislature, a problem that clearly could not have been anticipated. There you see room for using the modern methods. So you will keep applying exegesis or the traditional methods to new or recent laws. And many of the laws that you will be applied are new or recent laws. You also apply this method when you are dealing with older laws, and legislative intent must be taken into account when you deal with facts that could have existed when the text was written. You know, sort of old code, old problem, okay? Problems of murders, problems of sexual assault, etc. All these things have existed at all times. So even if the law was written a long time ago, there is no change. The problem had already been identified. There is no reason here to move to to the modern method. So overall, more than 90% of interpretation, I would say 95, 96, maybe 99, it depends what field of the law you are in, is traditional, is exegesis. You will only apply the modern method when you have an old code provision. You have, the code seems to speak possibly to the problem, but the problem is new, has not been anticipated by legislator. Old code, new problem. There you may move with the modern methods. Or when the code is silent, when you have gaps and lacunae, as we have discussed. By far, that is a minority of cases. And of course, there is always the risk of excessive judicial activism. Expect scrutiny when you are doing this. But guess what? Oftentimes in France, it's the Court of Cassation itself that engages in judicial activism, sometimes with the resistance of the court below, who show more willingness to stick to the traditional approach. Don't forget in that debate, whenever you think, can I combine the classic and modern method, that the civil law is in essence, is by tradition, a written law, a law in the book, a law in the codes. And the French scientific research must not mean legislating from the bench ex nihilo, as if no text existed. Geny may have pushed as far, but Saleh eventually prevailed with this beautiful sentence that you have to memorize: beyond the civil code, but by the civil code. Wherever possible, judgments should be based on a text. And that will be the final word to this lengthy presentation. Never forget these essentials. Legislation is never to be set aside and ignored. The civil code is a system, and its consistency must be maintained. The civil code is the general law. Revised statutes, ancillary statute, or satellite codes are special laws. Don't forget this distinction between general laws and special laws. And you apply the special law when the situation falls within its scope. You come back to the general law when the situation falls outside the scope of the special law. That slide actually gives you a sort of takeaway, snapshot, if you will, of all what we have discussed in these lengthy videos. Thank you very much for your attention, and please send along your questions or ask them live when we meet during our Friday class.